speaker to decide. What is the, Malad, what is the,
No.
Malad, they have not filed a reply till date.
No, but the question is who decides? I mean, the court can't take a decision.
But why not? Malad, the court decided. The court decided, Malad, in Rana.
Well, the power to decide a
They
disqualification.
did decide in Rana, Malad. 5 judges decided in Rana, saying that we will not send it back. The facts were undisputed. Malad, what is the, there can be no defense, Malad, because under the 10th schedule, there is no defense except a merger. What is the speaker to decide? And then your lordships will say, we can't issue a mandamus to the speaker to decide within 7 days. Then there'll be a constitutional issue referred to 5 judges then. Because you can't issue a mandamus to the speaker. Justice Nariman says within 3 months you should decide. No speaker accepts that judgment. Oh, where are we going?
Got referred to Constitution bench.
Where are we going, Malad?
Chandra.
Malad, the point is,
For raising the question, it'll require reconsideration of key.
I'm myself saying so, Malad. No, you please, whatever it is. I've said so twice already. It's only a merger, Malad. That's not their case.
But, Mr. Sibal, just as you say that, look, on the 27th, the speaker could not have been stultified in taking a decision on the disqualification petitions. Once we adopt that principle, then we have to be consistent and apply that principle across the spectrum. Because there's a very valid point which you are making, which is that the speaker himself is a or the speaker themselves, I shouldn't say himself, the speaker themselves are constitutional authorities. Therefore, the speaker has to take a decision under the 10th schedule.
Right.
If that is so, then we have to be extremely circumspect about, replacing the mechanism, the institutional mechanism which has been provided by the 10th schedule itself.
The problem in this case is, Malad, that this is because we perpetuated an illegality. Now the speaker came into existence by perpetuating an illegality. And now you are giving the clause of authority to that speaker who has actually come into place because by
we can't reinstate the earlier speaker because there we are drenching upon the authority of the House.
You did it. In Nabam Rabia, you did it. You in fact reinstated the entire government. I'm not saying you should do it, Malad, but if your lordship asks me that question, that's exactly what happened in our list.
Mr. Sibal, would the court not be getting into the thicket of the entire gamut by virtually clothing itself with the powers of the speaker?
Malad, no, because the facts are undisputed, Malad. That's why I said these are undisputed documents. There is no political thicket here.
What you're saying is put the clock back in every which way. When you say a speaker,
Because what?
Ultimately, Mr. Sibal, it will boil down to this. You have to say that, well, if you are logically consistent, that retrace your steps to the position in which we were before the 27th of June.
That's what I said.
The political.
When I argued Nabam, that's what I said, and the court accepted it. That's exactly what I said. Because you cannot, this is all staring us in the face. As I said, forget a majority, minority. Even 5 people can dislodge a government by saying that, all right, you have a trust vote now, new speaker is appointed, then every time the same thing will happen. Your lordship looks at it the other point of view. If you do not, stop this menace now, it will be perpetuated. That's the other issue. I'm not saying your lordship, whatever your lordships will do, will be acceptable.
No, we are trying to explore that even assuming that your argument is correct, where does it leave the constitutional court to? I mean, therefore, that's something which we'd like.
There are many things you can do. Malas, your lordships can say you decided within 7 days only and you challenge the order if it's against you before us after 7 days.
Sorry, come again?
You decide it within 7 days. They have not even filed a reply. Yes, let's assume, I'm giving your lordships your options. Decided within 7 days. We are sitting here. If there's an order against you, come up and appeal and then we'll decide the matter.
That speaker.
In fact, the speaker issued notice against us, Malas, on the 8th of July. He has not even issued notice in the matter, in our matter.
So to have clarity, Mr. Sibal, you say that, well, ask this speaker to decide the disqualification of the 39 MLAs. Ask him to do so within a stipulated period. We will then challenge. There are two options. The speaker may come to the conclusion that they are disqualified. Then what happens?
Malas, then what happens?
What happened?
These 39.
They will
these
come,
39
Malas. They will come in appeal.
No, but then how does that affect, what is the consequence practically in terms of the trust vote which takes place?
Malas,
The speaker, all right, assuming that the court has the power.
the
and the
chief
court
minister
passes-
will go, the chief minister will go,
How?
but 164(1)(b). He cannot hold office. 1 second, hold on.
Thirty-nine people will go out if the
And he
speaker
will not be able to
disqualifies
be
them.
chief minister. He will not be chief minister.
Like 39 people then, if your argument is right, if the speaker holds that, well, they're not disqualified, then you have a right to challenge that order before an appropriate court.
Not appropriate before your lordship.
Fair enough, whatever. If the speaker comes to the conclusion that there is a disqualification, those 39 persons go. In this case, according to Eknath Shinde also, therefore, has to
Yes.
move out.
Yes.
Then what is the next? What is the sequel?
Nothing, then whoever is the chief minister will get back on the trust vote. We'll see about that.
Yes, isn't it?
This court's order on 29 said trust vote is subject to these petitions.
See, the question put to you is,
All proceedings, Malas, all proceedings. But this is the problem, Malas. The judicial orders are passed. We are put in this situation. Then we are asked, what can we do now?
No, we are not saying what can we do.
Yes,
We
your
are,
lordship are
we are
saying what will
asking you,
happen.
what is your submission on what we can do?
No, Malas, what your lordship are putting
Mr.
to me.
Sibal, ultimately, you are arguing a constitutional point, but we have to also factor relief which a constitutional court then should give or is capable of granting within the format of the constitution to take the argument to its logical conclusion. So we're not for a moment saying that your argument is incorrect. What we are trying to do now is to test what are the limits of your argument.
As I told you,
How far does the court
the
go?
limit-
I mean,
Your lordship is right. That's why did I say 7 days, Malas? Because your lordship puts it to me. Ultimately, what should be done? And I said to your lordship, all right, give him 7 days. But then the question will arise, can you issue a mandamus to the speaker to decide within 7 days? And there'll be a constitutional crisis because the speaker will not obey.
We don't know.
I don't know. That's,
Subject to
it is possible. It has happened before. It has happened before.
Meghchandra is the only case where there is a direction for an early disposal of the petition. That's the only exception.
Yes,
And that again got referred to a constitution
That-
then saying that you can't direct the.
correct. Normal's
But.
Justice
right,
Nariman's
but it's
judgment.
still-
The same thing happened. Problem is, sorry. Fundamental issue. We've challenged Muller's decision of 3rd of July of the Speaker. Well, we are the party. That's fundamental before anything is done by the Speaker. So your lordships will, my respect would please consider the decision, then whatever the outcome is, let the outcome be. But a shortcut of this nature